number 61, the people of the state of New York versus Roque, Silvagnoli.
Good afternoon, Your Honor. I'd like to reserve 2 minutes for rebuttal.
You may have 2 minutes. And counsel, can we answer a purposefully exploitive analysis question under Cohen as a matter of law?
Yes, Your Honor, you may, and for 2 reasons in this case. One, similar to Cohen, the appellate division here did not apply the standard that this court articulated first in Irmo and later reaffirmed in Cohen, and that is a question of law that this court can resolve. Secondly, this court has also held in Mims and in Farrow, which are cases we cite in our reply, that when you have undisputed facts and also that there's only one reasonable inference to be drawn from those facts, that's also an issue that this court can decide. And we would submit, certainly with respect to whether or not the questioning in this case constituted a crucial element or in any way influenced the ultimate confession, there is only one reasonable conclusion or inference to be drawn here, and that's that it did not influence this confession. So that's the second reason why I think this can be decided as a matter of law. And in fact, in People v. White, which was a case we cited in our reply, in an analogous context, the attenuation context, this court did exactly that. It decided the issue as a matter of law, and the analogous issue was whether or not improper questioning, in that case a Miranda violation, had influenced subsequent statements that the defendant made. And on very similar facts, this court decided as a matter of law that those subsequent statements were admissible. Specifically, those facts were that there was only 5 minutes of improper questioning in White, very similar to here. It's as the appellate division concluded, a brief reference to a represented case. There was a 15 to 20 minute break in White between the improper questioning and when the statement is ultimately made. Similarly here, there's an even longer period. It's at the very least 20 to 30 minutes, and that's if we assume that this improper questioning came up at the very, very end of the second part of the interview, before the defendant ultimately makes any inculpatory statements. In White, the defendant's given soda and cigarettes. Here, the defendant has a meal before he ultimately confesses. The defendant initially in White gives an exculpatory statement, just like the defendant here when this reference comes up and he says, well, that's about drugs. I didn't have anything to do with this murder. He specifically exculpates himself in the murder. And finally, the fifth way in which this case is similar to White is that in White, the defendant only confessed after his exculpatory statement. His alibi was blown up by the police. Judge Stein,
I'm just thinking about what you said about only one reasonable inference. I think for me it's a closer question on whether the questioning is discrete and fairly separable, whether that's a factual question or not, or one in which you have to draw inferences. But when we talk about intent, and the second part of that test is exploitive intent, we generally say that's a factual question, and I'm having a hard time getting to, under the facts of this case in particular, but in general, how that cannot be at least partially a mixed question.
Right. So let me say 2 things. So one, you're absolutely right. Purposeful exploitation is what is prohibited. That's what Irmo talks about. And there's sort of 2 components to that. One, there's an intent aspect, which is, what was the detective thinking? Was he trying to use this questioning in order to elicit a confession on the unrepresented case? Then there's a separate aspect to it, which is, did that questioning actually matter? Did it affect the ultimate confession? This is what Irmo says was it a crucial element in eliciting the confession? That's a direct quote from Irmo and one that Cohen picks up on as well. Cohen phrases it also differently at the end of the opinion, where they talk about, was the confession influenced by the taint or
Well,
uninfluenced by
that
the
may
taint?
have been something that they analyzed, but I don't read Cohen as saying that's a part of the test.
I think it's definitely, I mean, that's part of the analysis. I think the discrete and fairly separable inquiry is how you determine whether or not the questioning was both purposely exploitive, was it meant to exploit the improper questioning, or excuse me, yeah, it was meant to exploit the improper questioning, and also
You're kind of merging those two together then.
no, I think it's all part of the question of whether or not it's purposefully exploitive. And I think we determine that by looking at whether or not the questioning was discrete or fairly separable. That's the objective way that we look and try to answer the ultimate question, which is purposeful exploitation.
I think we start with the premise that all police questioning is to get exploited answers to be used against the person that's being questioned. That's a given, right?
Yeah, yes.
So we're really talking about here you got the question designed about the drug deal, and which the court refers to as a single flippant remark. The defendant then responds that it says, well, yeah, maybe I got arrested for that, but I didn't do what I'm being questioned about here. So that did elicit a statement on an unrelated matter. That seems pretty clear. So then it comes down to what Judge Stein's talking about, which is the purposely analysis. And so is it a flippant statement or is it a purposeful statement, I guess, right? Isn't that what we're left with?
That's part of the analysis. You have to
So
determine.
if that's part of the analysis, it's difficult for me to see how that's a matter of law. That's what I'm struggling with.
So I think, again, the only reasonable conclusion to be drawn here is that it wasn't purposeful. And I think you have to look at the fact that it's one statement that comes up during the course of a 3+ hour interrogation.
And both the majority and the dissent agree that it's flippant.
That's absolutely
They
correct.
both use that characterization. And so I guess the question then is there any record support for finding that it's purposeful?
So I entirely agree, Your Honor. Not only did all 5 justices on the appellate division agree that it was flippant, that was an observation that was made by the suppression court, which of course had an opportunity to view Detective Ocasio as he was testifying. And I think there is record support simply from the fact that it comes up one time during the course of this interrogation. And it's
Well,
also,
record support that it's flippant.
Yes.
But what I'm saying, asking is there any support for the majority's later characterization of it as purposeful?
there's not. And the reason why is I think if you view it in context, it only comes up one time.
Yeah, but the context of it was to show how much they knew about his drug-related activities. So I think that one could infer that that was another notch in the link. I think I'm mixing my metaphors, but
I think then to the other point that was raised earlier, to a certain extent, you could characterize everything that's said during an interrogation as in some way being designed to ultimately get the detective further down the road of getting a confession. If that were the test, then virtually everything that was said, like any reference whatsoever to...
No, I think you're right about that. Of course, that's a given. That's what they're there for. That's their job. No, the question is, in engaging in impermissible questioning, was it purposeful? You know, the exploitation part, that goes with the territory. The purposeful part doesn't, particularly in the context of it being characterized as a flippant remark, as the judge was saying.
Well, and Judge Fahey, I think the reason why you can infer that it's purposeful here is not only that it comes up one time, but there's no follow-up after that. If the detective really wanted to use this in some way and exploit it, you would see something like you saw in Cohen, where they're bringing it up over and over again. They keep coming back to it. Or in Irmo, and actually both in Cohen and Irmo, it's not only the frequency, it's the structure of the questioning as well. In both of those cases, the detectives started their interrogations with the represented matter, and they used questioning on that to build their confessions or to build their interrogations on the unrepresented matter. And the appellate division decision in Irmo, I believe they refer to that as most significant. Same thing in Cohen. This court referred to it as particularly noteworthy that the structure of the questioning happened that way. We don't have that here, and so that's why I don't think it's reasonable to infer that this was purposeful in any way.
Thank you, Mr. Kraft. Counsel?
Good afternoon. May it please the court, William Carney for Respondent Roque Silvagnoli. The appellant division reversal was based on a mixed question of law and fact. It was an application of well-settled legal principles to an established fact pattern fully supported by the record. Neither the majority or the dissent actually disagreed on the legal analysis. They both applied the Cohen legal analysis, which this court is aware there's two.
Speaking of that, doesn't the majority opinion conflate or use elements of both of the Cohen sort of structure, the Cohen tests and mush them together? And haven't they erred as a matter of law then in doing that?
No, I disagree. They actually used the very same analysis in Cohen. There are two separate rules of Cohen, and so there's the inextricably interwoven and transaction related, and that wasn't actually in question in our case. But in Cohen, even
But doesn't
deciding...
the majority opinion actually talk about the space and the time, the fact that it's the same location? It looks to me like they're mixing up the two tests.
Absolutely
and
not. In
Isn't
fact,
that a legal error?
They applied the very same analysis in Cohen, because even in Cohen, where they decided under the second aspect whether or not it was a purposeful exploitation, and whether or not it was discrete or fairly separable, one way that they were able to find exploitation is to say that the detectives in Cohen linked the two incidents. They linked the Thompson garage and Sitco, even under that second analysis, and the court said that wasn't done, as in our case, that wasn't done innocuously. That was purposeful and showed bad intent because they joined the two subjects in the interrogation because they believed the two were related, and it implied significant knowledge of the damning connection between them and was designed to add pressure. And that's exactly what the detective did in this case, because he knew that the drug sale, which was it's approximately within the same temporal space, was 4 months earlier than this shooting, this murder, it was in the same location and involved the alleged motivation. So as the appellate division concluded, even if that was flippant, it wasn't done innocuously. It was done to advance the interrogation.
Well, at no point did they say to him, in terms of the structure of the questioning and coming back to it, they didn't say, not only did you sell to an undercover, but we know you're a regular drug dealer here, and because of that, and we know you were selling to him, and he owed you this debt. I'm not sure how they exploit it. What's the evidence that they exploited it
there's two answers.
purposely?
One, going back to the mixed question, that was the appellate division majority determination, and that's not unreasonable inference to draw from these facts.
Where's the record support for saying that that was purposeful?
It was purposeful, as the majority concluded, because they looked at the linkage between the two incidents, just as the court did in Cohen, when they said that even if it didn't meet the inextricably interwoven analysis, you could still look at the factual overlap to show their purposeful, in this case, bad intent, their exploitation of the counseled case in order to advance the interrogation on the uncounseled case. That was the analysis.
One of the things that, in looking at this case in the single remark, which everyone kind of minimizes, the one remark, it seems like almost like the appellate division has created a per se rule here where any reference, because this is a very minimal reference to a charged crime where somebody's represented, requires an automatic reversal on the uncharged crime. Do you read it that way?
I don't think that the court has to go that far. I think that what the court, there's two components. There's the discrete and fairly separable, and that can be answered in cases where there's a whole battery of questions that is repeated.
The reason I ask it is because of the minimal nature of the remark. And so that's why I'm saying, well, if this gets you a reversal, then pretty much anything will get you a reversal.
I think in this instance, because the linkage between the two, that is what the court looked to find the purposeful exploitation and the bad intent.
What is the linkage between the two? Is it
It has to do with the drug selling, which is the alleged motive for this
He's a drug
shooting.
dealer, right? I mean,
the
that's
si-
what he does.
Well, he actually didn't say, he never said he was a drug dealer. The detectives kept saying, oh, we know you're a drug dealer, and there's no admission until he brings up this thing, and then he says, oh, that's just drugs. This is different. But even then, he's gained an admission. So to the extent that he didn't persist in asking illegal questions, he'd already accomplished his goal by getting this admission and tying him to the motive to this shooting and in the same place. So he didn't need to persist in illegal questioning. I mean, the people's rule is, their proposed rule is that there has to be a pattern, but that really incentivizes bad behavior by the police, because how many illegal questions do they get before they reach a pattern? Is it like the 2 comments that are in this case, or is it 4 or 6? How many before that equals bad intent under their rule? That just leads to chaos in the system. When you have some, first of all, going back to the mixed question issue.
So what makes it flippant if they all think it's flippant?
I
Because
think-
you seem to be arguing it's not
seemingly-
flippant.
Well, first of all, they want to characterize flippant as merely frivolous, and they do that by taking one definition and then attaching another definition to it. But flippant also means rude, disrespectful, and sarcastic. So in that sense, it was designed to get under his skin, to imply, as the court said in Cohen, the damning connection between the two, significant knowledge of a damning connection between the counseled case and the uncounseled case. So yes, it may have seemed offhand, but it definitely had a purpose and was designed to communicate to him, we know you were selling drugs, and that's the supposed motivation for this shooting, and in the very same place, and less than 4 months before the shooting occurred. So that is but at the very least, for the appellate majority, that's a not unreasonable conclusion to draw from these facts. I mean, going back to the mixed question issue, even the dissent agreed with the legal analysis that the majority put out. They just thought that because it wasn't a whole bunch of instances, that wasn't sufficient. So they thought that. But the majority was able to say, well, no, it wasn't innocuous under these circumstances and in context. And whenever the courts talk about in context, of course, that's almost always a factual determination and drawing inferences from the facts that reach context. And so that very much means that's a mixed question of law and fact. Unless there are any further questions.
Thank you, counsel. Counsel?
Yes. There are three points that I would like to make in rebuttal. The first is a quote from Irmo, where they say that the police exploited conceitedly impermissible questioning as to the assault for the purpose and with the effect of advancing their interrogation on the homicide. So there's
But that doesn't mean that it's required. It just means that that's what happened here, and so they did something wrong, and as a matter of fact, it succeeded.
well, I think then to come back to Cohen, where they say that
And if it hadn't succeeded, we wouldn't be here, right?
Well, no, not necessarily, Your Honor. Yes, the defendant confessed, and what we're trying to determine is whether or not this brief and flippant reference had any role whatsoever in that. And I think, based on these facts, which are very similar to White, where this court held similar impermissible questioning did not have that influence, I don't think you can conclude that this question had any effect on the ultimate confession. But even putting that to the side, the preliminary question is, did the appellate division address this part of the analysis at all? And it doesn't. It quotes Cohen as saying that the police can't question the defendant in a manner designed to elicit a statement on an unrepresented matter. That's true. But that's part of the analysis. That's the intent part. It doesn't go to the ultimate taint issue, which is something that the appellate division just never addressed. The second point that I want to make is this idea that Judge Fahey was bringing up and that opposing counsel just raised, that, you know, getting under the defendant's skin, if that's your goal, that can't be enough to be purposeful exploitation under Cohen and Irmo, because if it were, basically any statement that's made about a represented case would meet that standard, because it's in some way designed to get the detective a little bit further down the road. My final point is that, along similar lines, if this reference is not discrete and fairly separable, I truly don't know what is. And if you look at the three cases that I think are the most factually similar to this one, which are Grant, Walker from the Third Department and White in the analogous Miranda context, all three, this court in White and the Third Department in Grant and Walker all concluded that the statements at issue should not have been suppressed. I urge the court to look to those cases. Thank you.
Thank you, counsel.